It is a great honor to welcome Robert P. George to this podcast. He is the professor of jurisprudence at Princeton University, and we're here to talk about his course, Constitutional Interpretation. How are you today, Robert? Thank you for joining us.
I'm very well. Thank you very much for having me. Always a pleasure to talk about the constitutional interpretation course.
Awesome, because so a non-American, so it is wholly beneficial to for someone to talk about this magnificent document that governs the law of your country. But first, another great American phenomenon, bluegrass music. You are a musician of that particular genre and that fabulous musical genre. So, tell me about your involvement in it.
Well, I'm a bluegrass banjo player. Um, I came by it honestly. I was born and brought up in the hills of West Virginia, where bluegrass music and mountain music are native genres. Bluegrass was really the soundtrack of my life growing up as a boy in those beautiful hills in West Virginia. West Virginia is right in the heart of the Appalachian Mountains. Uh, and I love playing. I continue to play. I do a bit of performing. I'm too busy with my academic projects to be a regular band member, although I've done that before in my past. But I occasionally will perform as a guest performer with bluegrass bands. And when I'm not performing, I love to play at home. When I am at home and not on the road, I play pretty much every night
Mhm. So,
just to entertain myself.
mhm.
What
So in
about
my
you?
view, Alison Krauss is the most famous and greatest bluegrass
Uh,
player. And to what extent do you find her to be influential to your music?
Well, she's wonderful, and she's wonderful because while she has her own distinctive sound and her own distinctive interpretations of bluegrass songs, she's deeply rooted in tradition. She's faithful to the tradition of bluegrass music. In this way, she's very much like Emmylou Harris.
Mhm.
She has her own style within the general bluegrass genre, but it's one that's very deeply rooted in the tradition. It still sounds like bluegrass. So I love Alison Krauss's music. She's a fine violinist, fine fiddler,
Mhm.
a wonderful singer. And her band, Union Station, is just terrific. I especially admire her guitarist, Dan Tominski, who has a solo career of his own, but also plays with Alison Krauss. They're great musicians, and again, I love the fact that they're just deeply rooted in the tradition while doing their own thing.
Mhm. So another aside, I was introduced to you by Professor Cornel West, who's currently running for president, I think in the Green Party as of today. And the fact that
That's correct.
the enduring friendship between you and Dr. West is a very hopeful sign in an America that, from an outsider's perspective, very, very divided. So, how what would you say about the importance of making friendships across the ideological line, exemplified by one between you and Cornel West?
Well, Brother West is my beloved friend. Uh, he is a beautiful soul. He's a beautiful man. I love him. He loves me. We love each other's families. We're integrated into each other's families. I knew his wonderful mother before she died, Irene West. She's a very distinguished educator out in Sacramento, California. He knows my parents, who are now 97 and 90. I'm close to his daughter, Zaytun, who was a student here at Princeton, and when she was an undergraduate, was an undergraduate fellow of the James Madison program that I direct. Cornell knows my children, my son and my daughter. He was at my son's wedding uh, about a year and a half ago. So we are real soulmates, Cornell and myself. Despite, as you say, those political differences, he's man of the left. He's the honorary chairman of Democratic Socialists of America, and as you pointed out, he's running for president. on the Green Party ticket. I'm on the conservative side, um, but those political differences in no way impede our friendship, our love for each other, our commitment to each other. Uh, I learn from him. He learns from me, he says, which pleases me. Um, we kick ideas around. We know we can trust each other. We don't have to put up any kind of barriers between us to protect our ideological interests. He can express doubt to me about some of the ideas that are prominent on the left. I can express my doubts to him about some ideas that are prominent on the right. I know I can go to him for an honest critique of my thinking on an issue. He knows that he can come to me for an honest critique, and we do that with each other. We share a lot of interests and commitments that go beyond politics and are much more fundamental than politics. First of all, we are both deeply committed to the vocation of scholarship, which both of us see as a truth seeking vocation. We both understand ourselves in the tradition of Socrates. We are Socratic in our commitment to truth seeking. We're both committed teachers, and both of us believe that teaching is something very different from indoctrination. We do not indoctrinate our students. We do not tell them what to think. We don't see it as our job to get them to think the way we think about politics or anything else. We understand our mission as one of empowering our students to think more deeply, more critically, which always includes self critically, and above all, for themselves. So they're genuinely thinking, not just parroting back to us what they think we want to hear. I have taught with Cornell on numerous occasions. We've done seminars together. I've seen him in action, and he is a true master teacher. He does not indoctrinate his students, quite the reverse. If a student is agreeing too much with him, he'll play the devil's advocate and challenge that student. And I do the same thing. So we are completely simpatico, and the chemistry between us in the classroom is really a joy. There's very few things in this life I enjoy more than teaching together with Cornell. And on top of our commitment to truth seeking as scholars and our commitment to genuine teaching as instructors, we share a deep Christian faith. Both of us have been on spiritual journeys. Both of us are believers in Jesus Christ and in his message, especially his fundamental message of love of God and love of neighbor. That's the foundation of our lives. And so that's a lot to share, even if we disagree about political things and some other matters. That's a real deep sharing. You can build, and we have built, a true brotherhood. This goes beyond friendship. It's more familial than the term friendship ordinarily connotes. So we built a real brotherhood, a real fraternity on the basis of these shared understandings and shared commitments and shared sense of mission.
I cannot help but be amazed at every time I listen to Dr. Cornell West. I mean, he has this wonderful ability to draw from his wealth of references, from
Oh,
Dostoevsky to John Coltrane and the like.
that's right. T.S. Eliot, Aretha
Mhm.
Franklin,
Mhm.
uh, he's amazing.
Yes.
We recently were at Chautauqua together, and we were supposed to fly up together from Newark to Buffalo um, for our discussion up there, and then fly back together. But our flights both ways were canceled. As a result of that, we had to get a car and be driven up to Chautauqua. When it was 7 hours one way and 7 hours back, 7 hours up there and 7 hours back.
Wow.
So we were 14 hours together in the car. And we hardly had a moment of silence. We were yakking with each other about everything you can think of. We share so many common interests. We were talking about Sophocles and St. Thomas Aquinas and Augustine and Kierkegaard. We were talking about Count Basie. We, we were talking about the Rolling Stones. We, it was just one thing after another. We have so many shared interests: poetry, drama, music. On top of our interest in ethics and philosophy, in political philosophy, those kinds of things.
Mhm. That must be a fascinating conversation to be a fly on the wall of. So, which brings me to the topic of, well, higher education, so to speak. So you and I, we're both familiar with the atmosphere of higher ed. You more in the American context than I am. But the way I see it, I think higher ed is generally leans more liberal. And as such, in America, there are these certain conservative enclaves. I guess you can count, there's the William F. Buckley Jr. program at Yale, or the program for constitutional government at Harvard, or I suppose the James Madison program at your university, Princeton. And as such, I worry that as universities become more to the liberal side or more to the left, these conservative enclaves might be more leaning towards the right, and that may create a dangerous political division, yeah, comparable to that of the country at large. So,
Yeah,
drawing from
I
your,
don't think.
yeah,
I'm sorry. I stepped on what you were saying. You hadn't
uh,
finished.
I just so my question is drawing from your friendship with Cornell West. Do you find that there needs to be this kind of more reaching out across the political divides as such?
Oh, certainly. No question. That's true in our politics generally. It's true in our institutions, including our educational institutions, especially our higher education institutions. It's even true in families. A lot of families are divided politically, and sometimes those political divisions these days really alienate family members from each other, and that's sad. That shouldn't happen. We should be able to disagree about politics, even very fundamental, important issues in politics, while still loving each other. I don't think universities should be ideological, and I don't think programs within universities should be ideological. I recently had an article in The Atlantic in which I made the case against what I call turning universities into ideological churches. That's really what has happened. Universities and programs within universities have become ideological churches. They take stands on political questions that are in dispute among reasonable people of goodwill. And I just think that's a mistake, at least for non sectarian universities like Princeton or Harvard or the University of Chicago or Stanford or Williams or Swarthmore. Now, with religiously affiliated universities, they have good reasons not to be neutral on certainly on moral questions, including morally inflected political questions. But at least when it comes to universities like the ones I've mentioned, they should provide the forum for students and faculty representing different points of view to air those points of view and engage each other with no thumb on the scales from the university. But unfortunately, that's not what we have. Too many universities and programs within universities have become ideological churches. They have doctrines, they have dogmas. Students feel they can't question them. Even faculty feel that if they dissent or express their dissent, if they do dissent, they will be estranged or pushed out or marginalized within their programs. And that's bad. That's bad for the truth seeking mission of the university. That's what universities are. They're truth seeking institutions. Otherwise, there's no reason for them to exist. And if you ideologize the university, then what erodes is their sense of that truth seeking mission. Um, so I don't want programs like the James Madison program to become ideological programs. I don't consider it a conservative program. I'm a conservative. And because I'm a conservative and I lead the program, a lot of people will just assume that it's an ideological program. But it's not. It is a program that allows different voices to be heard, including voices that are not common in other parts of the university or perspectives that are not frequently heard in other parts of the university. So I think it's a good thing to have a program that does help to diversify the voices heard within the university. So you do have conservatives. We bring in conservative speakers. We have events at which conservatives are welcome. But that doesn't mean we're a conservative program because we also have liberal students or even students who would not consider themselves liberal because they would consider themselves further to the left than the word liberal would suggest. And we bring in liberal speakers. For example, the late Justice Scalia, notable conservative jurist in the United States, was a speaker in the Madison program, a featured person on our campus. We brought him in, we had him give a public speech, we had him do other events, including dialogues with our undergraduate fellows, our students. But we did the same thing with Justice Stephen Breyer, who came, gave a public lecture, did other events, engaged with our undergraduate fellows. And Justice Breyer is to the left. Justice Scalia was to the right. We wanted our students to hear both perspectives. Now, it is true that in Princeton, at Princeton University, most of the faculty and most of the speakers who are brought in, most of the people you hear, and indeed most of the students are on the left. So if we're going to diversify things, one of the things the Madison program has to make sure and do is bring in a fair number of conservative speakers. But we're careful not to restrict our speakers to conservative speakers or to create an atmosphere that's inhospitable to liberals. If you look at our undergraduate fellows, we have about 250 of them. I would imagine something, close to half would consider themselves on the liberal or progressive side. And that's good. I like that. I think that's great. They will hear conservative perspectives, which will be good for them, and they will bring the liberal perspective into the conversation with the conservative students, which will be good for the conservative students. You see, this is how we learn. We learn when people with different points of view engage each other in a civil and serious manner, robustly, but with a concern for getting at the truth, not a concern for winning victories and scoring points.
Of course, what Justices Scalia and Breyer share in common is that they believe that the Constitution of your country, the United States, is the sui generis document in which all laws derive from, um, which, of course, brings us to the topic of the hour. Um, the, mm, the constitutional system, as I read it, contains in it divisions that most Americans find to be necessary. Well, there is the division of powers between the three branches of the government, right? The executive, legislative, and judiciary, as well as the division of power shared between the federal government and state local government. So how is this form of division necessary, and how is it different from, say, the ideological division that we've touched on?
Mm-hmm. Okay. Well, how did we get the Constitution in the first place? Let's start there. And what was the Constitution meant to do? And why did the founders think that was a necessary and good thing to do? Obviously, Americans who were colonials, controlled by their colonial masters, Great Britain, the king and parliament, fought a revolution when they believed that the king had become tyrannical. They did not, I think, in many cases, expect to win that revolution. It was against all odds that they did win it. I think they themselves, in many cases, were surprised that they prevailed because they were taking on the greatest power on earth. And in those days, Britain's military might was tremendous. The British Navy, phenomenal. Um, but they did prevail. And when they prevailed and gained their independence, the new states, the former colonies, there were 13 of them, had to figure out what to do. Should they be separate countries, 13 separate countries? Or should they in some sense be united? If so, in what sense? How autonomous should they be from each other? And how united should they be? So they had that question. An even more fundamental question was this, in a certain sense: what form of government shall we have? should we have our own monarchy? And some Americans favored that, and especially some Americans favored it because they had a great possible king in George Washington, the general who had led the nearly miraculous effort to liberate the United States from Great Britain. And he was all the more attractive as a candidate for king because he didn't want to be king. That's the best kind of king, a king who doesn't want to be king. But of course, they considered alternatives to monarchy. After all, it was the British monarchy that had become tyrannical. They wanted to avoid a homegrown tyranny. And you might have a great king in George Washington, but who's going to be the next king and the next king after that? How do you avoid a tyrannical king arising? So they considered an alternative to democracy, which they called republicanism, establishing a republic rather than a monarchy. What is a republic? Well, Lincoln would, years later at Gettysburg, 7 years later at Gettysburg, talk about the United States government as a government of the people, by the people, and for the people. Well, all government is government of the people, right? All good government is government for the people. Even the government of a benign despot, like a good king, is government for the people, not for the interests of the king or his party or clan or family, but government for the common good, government for the people. What's distinctive about Republican government is that it's government not only of the people and for the people, but government by the people. Now, we today, in this age that glorifies government by the people, we call it democracy. The American founders did not like that term, did not favor that term. They identified that term democracy with mob rule. They prefer the term republic, but whatever you call it, what's the problem with government by the people? Why not just immediately go to that and say, man, that's better than a monarchy? Well, the trouble was all previous attempts to establish republican government throughout history, whether in the ancient world or the medieval world or the world of the Renaissance in Europe, had failed. And very often, when republics had failed, not only had they failed, they'd collapsed into the worst forms of tyranny, which led many people to believe by the 18th century that human beings are just not fit for self-government. The best we can do is a benign monarchy and hoping for the best for the future. But our founders, the American founders, decided, you know what? We think we can make Republican government work. We think we can learn from the failures, the collapses of earlier republics, whether in the ancient world or the medieval world or later, and we can rectify the problems that caused those republics to fail and to collapse in many cases into the worst forms of tyranny. How are they going to do that? By limiting power, by checking power, not by simply putting into a constitution a Bill of Rights, but by creating a constitution that would ensure that nobody had too much power and that everybody who had power had that power checked by somebody else with countervailing power. And you see this at the two levels that you yourself indicated in your question. First, there's the division of power between the national governments and the states. Second, there's the division of power within the national government between what we call, and you called, the branches of government, the executive, the legislative, the judicial. On the first one, it's very important to understand that the American founders established the government of the United States not as a government of general jurisdiction empowered to do anything not put off limits to it by the Constitution, but rather they established the government of the United States as a new kind of government. That is a government of delegated and enumerated powers. The national government was only given the power to do certain things. And where a power had not been given by the Constitution to the national government could not exercise that power. In that case, that leaves the question, well, if the national government can't exercise it because the power hasn't been delegated by the Constitution, by we the people through the Constitution to the national government, who has that power? And under our Constitution, the Constitution of the United States, that power is with the states. So the states have plenary power. They are governments of general jurisdiction, exercising authority over any area that has not been either delegated to the national government or put out of bounds to both the national governments and the states. So, for example, states are prohibited by the Constitution from granting titles of nobility. Neither the national government nor the states can do that because titles of nobility are incompatible with the idea of republicanism. In republicanism, everybody is equal as citizens. We don't have dukes and earls and counts and barons. Everybody's equal as citizens, political equality. There may be lots of other differences between people and inequalities, economic, social, and otherwise, but politically, everybody as a citizen is on the same plane. But where a power has not been assigned to the national government, delegated to the national government, or prohibited by the Constitution to the states, like granting titles of nobility, then the states have that power. And that's most areas. Under our Constitution, most areas are governed not by national authority, but by state authority. Take, for example, laws against rape and murder and theft. Most of those laws are at the state level, and they can vary a bit from state to state. And they do vary. They're not at the national level. We have no national murder law. Where a person is prosecuted for murder, with very rare exceptions, like killing the President of the United States, those are prosecuted at the state level. They're state crimes prosecuted in state courts by state prosecutors, subject to state homicide laws, including state defenses like self-defense or insanity or whatever the defense puts up as a defense to the charge of murder. So that's the first way the Constitution tries to preserve Republican government, protect liberty, prevent tyranny, by establishing a two-tiered dual sovereignty system with the national government sovereign where its delegated powers are in place, and the state sovereign where the delegated powers, where a power has not been, or any powers have not been delegated to the national government or put out of bounds by the Constitution to the states. Then there's the second way in which power is constrained and limited and checked, and that's within the national government itself. So the first article of the Constitution, the article that comes right after the preamble, which explains why we have the Constitution, the very first article begins with a sentence that says, all legislative powers herein granted, note the first word, all legislative powers herein granted, are vested in a Congress consisting of a House of Representatives and a Senate. Notice again the word all, not some, not most, not many, all. That means no president has any legislative authority. That means no judge, even the Supreme Court justices, have any legislative authority. All means all. Judges shouldn't be legislating from the bench. They have not been given that authority. Presidents should not be legislating, even if they're doing it under the guise of, let's say, executive orders, because all legislative authority of the United States, where the powers have been delegated, all legislative authority is vested in the Congress. The second article says that the executive power of the United States is vested in the president, who sits atop the executive branch. with his cabinet and the various agencies. And then the third article of the Constitution vests the judicial power in one Supreme Court and in such inferior courts as Congress shall from time to time ordain and establish. You know, it's interesting, Chung. The Constitution only establishes one court. That's the Supreme Court of the United States. It doesn't establish trial courts. It doesn't establish intermediate appellate courts. We have them, but we have them not pursuant directly to the Constitution, but we have them because Congress has acted on the power conferred on it by the Constitution to create what it perhaps infelicitously to our ears calls inferior courts. So in order to have trials outside the limited areas where the Supreme Court itself has original jurisdiction and can hear trials and find facts, outside of that very narrow range, Congress needed to establish what we call district courts to be the first stage of a trial, whether it's a civil trial or a criminal trial. And that's the stage at which the facts are found, ordinarily by a jury, unless for some reason you don't have a jury trial and it's a bench trial and the judge is both the applier of law and the finder of fact. But the norm is for a jury to find the facts at the trial court level, which in the federal system is called the district court level. Now, if, and again, whether it's a civil matter or a criminal matter, if you don't like the result, if you're a party and you lose in the district court at the trial, and you think the judge made a mistake of law, you can appeal, but you can't appeal directly to the Supreme Court ordinarily. You've got to appeal to an intermediate court of appeals. We call them circuit courts in the federal system. And there are various circuits. They're numbered. The First Circuit, the Second Circuit, the 11th Circuit, and then one that goes by the name, the DC Circuit, the District of Columbia Circuit. You go there for a review of the trial court. And that U.S. Court of Appeals, let's say for the Fifth Circuit, can overturn the district court, the trial court judgment, if the appellate court decides that an error of law was made and was relevant and determined the outcome at the district court level. For the party that loses at the Circuit Court of Appeals level, you have the option of petitioning the Supreme Court to review the appellate court, the intermediate appellate court, the Court of Appeal, the Circuit Court. The Supreme Court, though, again, ordinarily, is not required to take your case and review it. It can simply decline to take your case, leaving standing whatever the outcome was at the Circuit Court of Appeals level. And for the vast, vast, vast majority of petitions to the Supreme Court, that's in fact what happens. You'll have several thousand petitions every year to the Supreme Court to review decisions of the lower courts, and only a handful, less than 100, will be reviewed. And in some of those cases, the Supreme Court will uphold the judgment at the Intermediate Court of Appeals level, and in other cases, it will overturn them. We had some very high-profile cases recently in which the lower court judgments, the Court of Appeals judgments, were overturned. I should add, just to conclude this part of the discussion, that it's also possible to petition the Supreme Court for review of judgments of the Constitution or federal law by state courts. Where a case has come up through the state courts, and it's resolved, of course, unfavorably to one party or the other. So it's resolved unfavorably to a party who believes that the state Supreme Court, let's say, has misunderstood or misinterpreted or misapplied federal law or the Constitution of the United States. You can petition for review by the Supreme Court from the state system to the Supreme Court. And again, the Supreme Court can decide to uphold the state Supreme Court judgment of, say, what the First Amendment to the Constitution means in a free speech case or freedom of religion case, or rule that the Supreme Court of the state of Utah or West Virginia or New York or California misunderstood or misinterpreted or misapplied the law, and the Supreme Court can overturn the judgment. So that's how it works.
So I read a piece on the news about John Eastman, I think a noted American constitutional scholar and currently sitting on the defense of President Donald Trump. And he made a move that I find to be quite surprising in that he invokes the Declaration of Independence as American law, so to speak. To quote him, there's actually a provision in the Declaration that a people will suffer abuses while they remain sufferable, tolerable while they remain tolerable. At some point, abuses become so intolerable that it becomes not only their right, but their duty to alter or abolish the existing government. Well, I mean, there is also the topic of whether the Declaration of Independence is actually American law, but also the idea that would it be legitimate to say, to decide that the entire federal system that you've wonderfully articulated is illegitimate, and if the majority of the people of America decides it to be so, create a new system from scratch. So, in other words, a second American Revolution.
Well, the Constitution itself allows for the revision of the Constitution. It even creates procedures for establishing a constitutional convention that could devise a new constitution, including one that wasn't necessarily Republican in form. So, that's taken care of. There's nothing sacrosanct about the Constitution of the United States. It recognizes that it's not the final word, that the final word is with we the people, but it establishes procedures for its own amendment, its own revision, even for a new constitutional convention, so that there doesn't need to be resort to revolution and violence. You don't want revolution and violence. The American founders themselves had fought a revolution. They know how bad it is. People die. People are killed. Women are widowed. Children are orphaned. It's terrible. So they, with their foresight, did not create a constitution that claimed to be once and for all, forever, not unchangeable. Like just the mind of God. That's not what they did. They created a constitution that provided nonviolent mechanisms for its own revision so that the will of the people could prevail. It acknowledges that the ultimate authority is the people. The Constitution begins with the words, "We the people of the United States." It's their Constitution. But we the people of the United States, have provided provisions for changing their minds even about the fundamental character of their government, but doing so lawfully and not with violence and revolution.
So
I hope the American Revolution was the last revolution that anybody on these shores had to fight, and I know that our founders felt the same way. They were not people who thought, "Gee, revolution, great. Let's have a revolution." They did everything they could to avoid having to fight the revolution in the first place. They petitioned the king to redress the grievances they had. It's when those petitions fell on deaf ears that they felt that they had no choice but to revolt. There was no peaceful mechanism. There was no constitutional method of having a constitutional convention, for example, to create a new government.
I think if you look at it from the Confederate States' perspective, they almost fought a second American Revolution in their attempt to secede from the United States. And
yeah, I think that's what they thought they were doing. I think their leaders and the people supporting them thought that that's exactly what they were doing.
I believe there exists a Supreme Court case whose name I cannot remember now, but I think Texas is one of the plaintiffs. But it states that you have no legal right to secede from the United States. And in the 5 years where Texas, along with the other Confederate states, decided that they did secede, they were actually not so.
Yeah, of course, this was also, and most importantly, it was Lincoln's view.
Mhm.
I mean, it wasn't the Supreme Court that put down the secession. The Supreme Court, as a matter of fact, was not friendly to Lincoln and the Union cause during that period. This was under Chief Justice Roger Brooke Taney, a Marylander. Um, it was really Lincoln's view that prevailed, that there was no right of secession. You couldn't respond to losing an election by leaving the Union. Your response to losing an election has to be, well, we're going to come back next time and win the election.
Mhm. Right. So I'd like to hear more about how Lincoln, I guess, revise or so to speak, improve upon the view that the founders of your magnificent country have laid out.
Well, Lincoln himself did not understand himself as revising in any way the principles or constitutional structures that the framers, the founders of the United States had put into place. He saw himself, he saw his own task, he saw his own mission as holding the country to the principles of its founding. Lincoln never tired of quoting the Declaration of Independence, and he felt himself strictly bound by the Constitution of the United States. Some of Lincoln's critics would question what I just said, and we could get into why they question it and what my response would be, but I do stand by it. For example, while Lincoln opposed slavery, he said if anything's wrong, slavery's wrong, or if slavery's not wrong, then nothing's wrong. He was a vehement opponent of slavery. He was from the first moment he had witnessed a slave auction. Um, Nevertheless, he did not believe that he or the federal government could abolish slavery under the Constitution. He thought they lacked the constitutional power to abolish slavery in the states that chose to have slavery. So he could not abolish it and did not try to abolish it in South Carolina or Georgia or Alabama or Louisiana. Uh, and this brought him tremendous criticism from the abolitionists. You notice Lincoln's not referred to as an abolitionist. He was an opponent of slavery. He wanted to get rid of it. He was willing to fight hard to get rid of it, but he was not willing to use unconstitutional means to do it, including by exercising power not delegated to the federal government to abolish slavery in the states. What Lincoln thought he could do under the Constitution, what he did was to try to prevent or restrict or prohibit slavery in the territories of the United States. These were sections of what was then the western part of the United States that were not states or not yet states, but were under the authority of the federal government. Lincoln reasoned under the Constitution that in those territories, since the United States, not a state, had general jurisdiction, the United States, that is Congress, could decide whether to have slavery or not. And he, of course, pushed legislation in Congress so that those territories would not have slavery. The Supreme Court, in an opinion by Chief Justice Taney, ruled that Lincoln was violating, or the Republicans, the Congress, Lincoln and his party in Congress that controlled Congress, were violating the Constitution by purporting to abolish slavery in the federal territories. This actually happened before Lincoln became president. A case in the mid 1850s called Dred Scott against Sanford. But Lincoln totally opposed that decision. He felt it was an unconstitutional decision unconstitutionally restricting federal power by Chief Justice Taney in the Supreme Court. He regarded it as a usurpation by the courts of the legislative authority of Congress, a violation of that principle in, in Article 1, Section 1, which says that all legislative powers herein granted are granted to the Congress, not to the Supreme Court. So um, that's how Lincoln saw his own role. He was both limited by the Constitution in what he could do and empowered by the Constitution as president with cooperation of Congress to do certain things. He wanted to live by the Constitution. If he had no regard for the Constitution, he would have simply declared slavery to be unlawful in Georgia or Alabama or South Carolina, or gotten Congress to enact a bill abolishing slavery in those states. He would have loved to have slavery abolished throughout the country. He made that very clear. But he didn't want to violate the Constitution even to achieve so noble a goal. That's how committed he was to the Constitution.
So I think we should mention the Dred Scott decision because it is considered the worst among the Supreme Court decision. Is the one that decided that slaves, even the ones who freed themselves, are not considered U.S. citizens. And in contrast, the Brown versus the Board of Education is considered the best Supreme Court decision because it decided that segregation in public facilities, including public schools, is against the Constitution. But it does poses a question on the centrality of the Supreme Court in deciding these matters. And to what extent can the Supreme Court be, say, morally neutral in even in like very pressing matters? For example, the recent Dobbs versus Jackson Women's Health Organization have returned, so to speak, the Supreme Court's neutrality on the legality and morality of, I guess, voluntary abortion. But nevertheless, the court is not neutral when it comes to segregating in public schools and other public facilities.
I'm sorry. So the question is,
to what extent should or is the Supreme Court neutral on these matters?
Oh, okay. Well, the law is not neutral, and it cannot be neutral on moral questions. Whether we are going to permit people to enslave other people, whether we are going to commit people to destroy a child in the womb, whether we are going to permit discrimination in housing or employment or in the provision of services or goods, all of those are moral questions, and no system of law can be neutral about them. I think it's a mistake to claim, as some political theorists do claim, that law should attempt to the extent possible to be systematically neutral as between competing ideas of what makes for or detracts from a morally upright or worthy way of life. I've been a critic of that claim to neutrality, sometimes called political liberalism, associated with the great Harvard philosopher John Rawls. I've been critical of that from the moment I began my academic career. Even when I was a graduate student, I was a critic of that view, criticized it in my own doctoral dissertation at Oxford. But the role of courts is not fundamentally to make moral judgments. It's to make legal judgments, including interpreting, applying, enforcing the moral judgments in the law made by the Constitution makers in the case of the Constitution, and by the legislators, state and federal, in the case of statutory law under our federal system in the United States. So I believe that judges have to understand the purposes of law in order to apply laws, and that will include understanding the moral purposes of the law. But I don't think judges are entitled, for example, to strike down legislation with no legal warrant where their objection to the legislation is purely a moral objection. That would be to overstep the line between adjudication, which is what judges are supposed to be doing, and legislation, which is what legislators are supposed to be doing. It's to blur the line between law, the legal, and the political, politics. Um, so I think it's important to catch all the nuances here. It's a mistake on the one side to think that judges don't have to have any moral understanding. They do have to have a moral understanding. To get things right, they have to understand that the law embodies a morality. They have to understand what that morality is. They have to understand the purposes of the law, including its moral purposes. You can't authentically interpret unless you do that. But they're not meant, judges are not meant to substitute their moral judgments for the judgments of the constitution maker or the legislator if they don't like them. That's what Lincoln was doing when he took the position A, that he could not, because he lacked the authority, abolish slavery in Alabama or Mississippi or South Carolina, but B, he was within his constitutional authority in acting for the moral purpose of abolishing or prohibiting slavery in the federal territories where the government of the United States, where Congress had delegated power and therefore jurisdiction. So do you see the nuances I'm driving at here, Trung?
Um, I would say I'm hoping to understand it, and by doing so, I would like to invoke an argument in opposition to, I guess, the Rawlsian political liberalism, and that's been recently made by another Harvard faculty member, Adrian Vermeil, in his book Common Good Constitutionalism. And I cannot claim to understand much of it, but as far as I can understand it, it aims to purport that the Constitution and all its laws has a purpose, and the purpose is to protect the common good. So, where do you stand on this particular argument?
I agree with Professor Vermeule's point that the law has a purpose and or a set of purposes, and that those purposes include, in a very central way, moral purposes. I heard Professor Vermeule give a wonderful presentation on this at the American Enterprise Institute at a conference on the jurisprudence of Sam Alito, a current Supreme Court justice, the justice who wrote the majority opinion in the Dobbs case. Um, Professor Vermeule made the point that Justice Alito's jurisprudence is not in any narrow sense originalist because it takes into account the kinds of considerations that were urged by an earlier Harvard law professor, the late Lon L. Fuller, in his book The Morality of Law, which put the focus on the importance of understanding the purpose of the law if you're going to understand the law. You can't understand the law, just the words on the page. You can't actually understand what it means without having some understanding of what it seeks to accomplish, including the moral goals it seeks to accomplish. And I completely agree with that. This purpose of understanding of the law is important. I think that when judges apply statutes, and especially when they interpret constitutions, they need to be looking to the text, the logical implications or presuppositions of the text. They need to understand what a provision entails logically and what it presupposes logically, because those are parts of the law. So the text, the logic of the provisions of the text, the structure of the text, often the structure of the institutions established in the law, say in the Constitution, or the structure of the provisions will shed light on the purpose and therefore the meaning of the law. And beyond that, the historical understanding. If you want to get at the purpose of the law, it's a good idea to try to understand the the what the law meant to the people whose ratification made the law no longer just somebody's idea of what a good thing to do would be, but actually made it the law. So if you ask me, where should judges find meaning? I would say in the text, the logic of its provisions, its structure, and its historical or original understanding, its publicly understood meaning. But there, what we're trying to do is to understand why the lawmaker, including the constitution maker in the case of a constitution, put into the law the provisions that are in the law. You can't just read the words on the page ordinarily. Maybe in some cases, rare cases, you can. President has to be 35 years old. That's pretty straightforward. But in most cases, freedom of speech, due process, equal protection, freedom of religion, you have to understand the goods, the goals that the legislator or constitution maker is trying to realize, achieve, advance, promote. So that all makes sense to me.
Mhm. So I think Professor Vermeil, yourself, and I, we're both part of the Catholic Church. We're both Catholics, and so to what extent is the other framers of the Constitution influenced by the natural law tradition?
Oh, no question. I mean, just read their works. They were profoundly influenced by the natural law tradition. Now, the natural law tradition is a very complex tradition, and it's fed by numerous streams. Um, the roots are in the thought of the great philosophers, Greek philosophers, and Roman jurists of antiquity: Plato, Aristotle, Cicero. But of course, there's a profound development of concepts of natural law by the medieval thinkers, preeminently St. Thomas Aquinas, not exclusively, but preeminently St. Thomas Aquinas. And then additional ideas are fed into the concept of natural law by Reformation and Enlightenment thinkers. And of course, there are disagreements within the tradition. I mean, there were disagreements between Plato and Aristotle. Plato was Aristotle's teacher, but Aristotle didn't agree with everything Plato taught about ethics and other things, although they were pretty close on ethics, actually. But there are going to be disagreements within a tradition. In fact, the great philosopher, contemporary philosopher Alasdair MacIntyre, talks about traditions as being sort of ongoing arguments. They're not monolithic, and that's as true of the natural law tradition as it is of the Jewish tradition or the Catholic tradition, or even within Marxism. Think of the different schools of Marxism, to just talk about a tradition that I don't have much sympathy with. Um, so there are different streams feeding the broad natural law tradition. There are different schools of thought within it, but there's no question that people like Madison, Jefferson, Hamilton, James Wilson, very explicit, the greatest lawyer of his generation in the early American Republic, were shaped by, their thinking was formed by the natural law tradition, and you see this being invoked even in the 20th century. Martin Luther King, in his letter from Birmingham jail, appeals explicitly to the natural law as the law by reference to which the human law, the merely human law, including the law of a constitution, can be judged and held to be just or unjust. King, in line with the whole natural law tradition, going all the way back to antiquity, going all the way back to what we'd find in Sophocles' Antigone or in Plato's writings, Aristotle's writings. King says, look, it's important to have human law. It's morally important to have human law. The worst situation you can have is anarchy, because there the strong just are predators on the weak. But it's important for the law to be just. The law is not made just by being the law. The law is just only if it's in conformity, he says, with the higher law, the natural law, and the law of God. If it's out of conformity with the higher law, then the human positive law is judged to be unjust. And King says really isn't law at all. That's an here King is invoking an idea that goes all the way back to Plato and to Cicero. You get versions of it. An unjust law is no law at all. St. Augustine says it, St. Thomas Aquinas echoes it. Now, that is easily misunderstood, and it needs to be clarified in a variety of ways. But what fundamentally it means is that an unjust law cannot bind the conscience of the person subject to it in the way that the just law binds the conscience of the person subject to it. Whether that person would make the law the same way himself or not, it still binds him in conscience. It creates moral obligation. An unjust law in itself cannot create moral obligation. So that's fundamentally what that idea of an unjust law as no law at all means.
So, final question. The Federalist Papers, which is central to our understanding of the US Constitution, was pseudonymously authored by Publius, and the Anti-Federalist Papers, one of the authors was pseudonymously named Brutus. So it is clear that the Roman Republic carried a lot of significance to these
Good point.
men living in the 18th century. So why is it so?
Well, the founders of America were the United States of America were learned men. Um, they were classically educated, not in every case, but in notable cases. They knew the classical tradition. They knew the literature, they knew the philosophy, they knew the history, and they would try to draw wherever they could on wisdom, including wisdom from those antique traditions. Shortly before he died on July 4th, 1826, I believe it was in May, so within a month or two, um, Thomas Jefferson responded to a letter from Henry Lee in which Lee had asked him, where did you get the ideas for the Declaration of Independence? They must have sounded to Lee as though they were very new ideas, cutting edge. Jefferson responds in an interesting way, especially for an Enlightenment figure like Jefferson. He responds by saying, oh no, there was nothing new in the ideas in the Declaration. They were old ideas. He said, I was just articulating in the Declaration. He was the author, of course, the principal draftsman. I was just articulating the common sense of the American people, which had itself been formed by the elementary books of right, in other words, of political philosophy, of justice. And then he mentions in a non-exhaustive list some ancient thinkers. I believe he mentions Aristotle, Cicero, as well as Enlightenment thinkers like Locke and Sidney. Jefferson recognized that there were multiple streams feeding the American founding ideas in the Declaration. There were natural ideas, there were biblical ideas. Judaism and Christianity had a role. Classical philosophy had a role. The experience of the classical world, the collapse of the Roman Republic, all of that helped to shape the consciousness, what he's calling the common sense of the American people. Now, Jefferson was not among the actual authors of the Federalist Papers. Publius was actually three people. John Jay, who became the first Chief Justice of the Supreme Court of the United States, first Chief Justice of the United States. Alexander Hamilton, of course, and James Madison. But Jefferson, I think, was saying what the actual three authors of the Federalist Papers themselves would have said. Their own writings make clear they're not cutting edge, articulating new ideas. It's a big difference between the American revolutionaries and the French revolutionaries. The French revolutionaries were repudiating the past and going to start a whole new world. This is going to be day one of the new world. Forget the past. Everything about the past is bad. Nothing to be learned from that. The American revolutionaries wanted to get the best of the past and avoid the errors of the past. And they knew about the past. They knew about its history. They knew about its philosophy. They knew about its literature. And they drew on that, and their sense was the American people, sometimes in very informal ways, nevertheless drew on that knowledge, that wisdom in doing what they did to make this new republic, one that would not collapse and fail like the previous republics, but would, if I can quote Lincoln years later at Gettysburg again, long endure.
Well, to quote from Winston Churchill, study history, for in history lies the secret of statecraft. Thank you very much, Professor Robert George, for this wonderful, enlightening interview.
Thank you.